Hey, everybody, we're live. We're a little late, but it's okay to be late. It's my fault. It's my fault. Blame me because I had a hearing this morning by WebEx. I hate WebEx hearings. That started 8:30, and we just got done.
That's because you're in your court clothes.
Master calendar here. It's a master calendar hearing in the case of Miss Sorokin this morning. So I hate WebEx. Have I told you how much I hate using WebEx? It's interesting to be, you're in our courtroom. Everybody's been in a courtroom, right? You can feel the courtroom, you can feel the energy. But when you're on WebEx, the camera is like on the ceiling or something, and it's definitely like watching sausage get made is all I can tell you. That's all I can tell you. But let's see what's going on today. I didn't even have time to post what we're going to talk about today. There's not much to talk about because nothing's happened. It's the end of July, and the courts are doing nothing. And government lawyers are doing nothing. And I can attest, yesterday I went to pick up a friend at the airport at rush hour in Atlanta, and there was no traffic. So everybody's on vacation, as I could tell. Everybody's on vacation. Greg is clearly on a quasi-vacation in the Windy City. Oh, you're muted, Greg.
You can see the L train behind me. It's very exciting. You might see the train go by during the stream.
So Greg is not in his normal covey back home. We have the other one here. Good to see Jesse. And Aaron, good to see you. I know we're all slammed today. It's like a crazy day today. So it's weird because everybody's on vacation and yet deadlines. So let's see if there's a couple things we want to talk about. We know I just want to post this. There has been no announcement of the H-1B lottery cap being reached. I just want to make a note in case somebody at USAA is listening.
We think but wasn't it 30 days last time?
I think it was July 27th when they announced the last lottery. I need to go back and look, but
so it's not that it's a right. It could happen any day.
Now, I mean, I do hear that they haven't even sent receipts notices, at least to some of our colleagues, for H's that were filed at the end of the month. I mean, really, a month later? What is this? Is this November 2020 all over again? We don't know about. There is another thing I wanted to talk about just real briefly, and just something that Greg has really pushed for, and this is the United for Ukraine program, where Greg and David Beer and others have pointed clearly out that USCIS is not following the law on allowing them to act as refugees and to work. Greg, have you heard any more? Any peep? Any whisper?
No, I've been kind of like trying to talk to people that were involved with the legislation to see if they know anything about it. And no one understands why USCIS has not posted anything regarding the legislation that was already signed. This is like the one piece of immigration legislation that's actually happened recently. And you would think USCIS would be all over it because they don't have that many bills to keep track of that actually have been signed by the president. So I haven't seen that. And then the other issue with the Uniting for Ukraine, I noticed, and Aaron actually kind of like tuned me in on this issue with the Afghan parolees, is that they're denying Ukrainians humanitarian parole without explanation, just like the Afghans. And the regs say you have to you can deny as an examiner, but you have to give specific reasons why you're denying. You can't just say you're denied, which is what I saw at least in one case this week. And I've seen in a number of Afghan cases. So that's sort of another problem that we're seeing with the Ukrainian program. And, it's one of these things that how does USCIS expect people to follow the law that they present to them and the rules that they present to them when they're not even following their own rules? So there you go.
Yeah. I would just say, I think the employment issue for the refugees is really coming to it's really, we try to talk to them, and, if they're not going to take action, I mean, these people deserve to be working. I mean, it's just a matter of,
Well, I guess do we need to make a call for plaintiffs and say, look, we're going to take this up and go for it?
I think we'll find plaintiffs really quickly on that. I just don't understand why this is one that I don't understand why they would argue with us on it. A, Congress just told them what to do, and B, they're complaining left and right about their I-765 workload, and here's an opportunity for them to deal with that issue. Maybe, and also, by the way, they're not supposed to be charging for these 765s either. That's the other part of it. The 765 is just evidence of employment authorization that they shouldn't have to file in the first place. But if they do file it, they're not supposed to have to pay for it, which is, and they're charging for it anyway. So that may have something to do with what their motivations are here. But none of it makes any sense to me.
No. I mean, there's really no, like, if you just take the immigration labyrinth away and the machinery and just say, okay, we know these people are going to be here. We're helping them out. Congress said they should be working like refugees can do right away. And we have an agency that's really standing. We put it to them, right? You say, hey, you're doing this wrong. And we have radio silence. And so it's tough for us as people who can represent the interest of those suffering to sit here and say, well, maybe we'll give them a little bit longer. I mean, I'm actually, frustrated for a number of reasons with a number of cases. But I mean, this is one where it just drives me crazy. I just don't understand it.
Well, I can start finding plaintiffs.
Let's do that. Let's do that, Greg. Let's do this case. This is going to be fun. This is going to be fun. And maybe we get to depose somebody. Maybe Urchadu is good on a deposition. I don't know.
Yeah, and I don't want to talk too much shop, but I mean, this is one where there's a phrase that I don't know how they could come back and say their position is substantially justified. And
there's no deference due here. And when the language of the statute is plain, there's no deference due an agency here. None.
Yeah, none. It's tough.
All right,
that's a good one.
This is one we hope USCIS is watching.
Sure. Right.
It's like, I hope you're there watching this, USCIS, and you're passing this around.
Yeah, I tagged them in my tweet, but I don't know if they read that. We've got just a quick one. We do have in our EB5 Jane, this is the 526 filings. We have a court hearing on a basically a status conference about discovery on August 8th. We sent an email out. Hopefully that went out. I don't know, Greg, did you get that out yesterday that I sent, or were you out of the office?
I was out of the office, but I thought you sent it this morning.
I sent it yesterday.
Okay. Well, it should go out today. I should when I get access to. Yeah.
And what we don't know is
I'll get that out later.
We don't know if anybody else can attend, so we don't have that detail yet. But if so, we'll send you a link that you can sign in and review and watch the sausage get made. Just to update you, we are pushing that case forward. Now, gentlemen, I mean, there's really nothing else going on. It's just.
Well, I think we could spend a couple minutes on
the wastage case. We can talk about
the wastage case, and then I think also the Friday night drop from the director of the Kentucky Counselor Center, Morgan Miles, that conveniently in our case anyway, they styled it as an errata to the declaration.
Ours as well.
It's a little bit more than an errata, but
let's do the EB wastage first, and then we're going to go to the DB.
Sure.
So, Aaron, EB wastage.
So we have an amendment, right, Aaron?
Aaron, you're muted.
We've had a number of people sign on during this window where we can do an amended complaint and file the amended complaint with additional plaintiffs. That will be done by the end of the week, and then the next step is I think a motion for a PI, which should be done next week. So things are moving fast now, and we will have, I guess, updates after that's filed. We'll have that available for plaintiffs.
Jesse,
this is another case. Obviously very different issues from employment for Ukrainian refugees, but this is another case where you have the agency out making promises, And we know from the numbers that, and what they're doing in the field, they're switching cases, they're transferring cases. I mean, this is one where we could come to a solution, right? And we've offered that. Hey, come to us, let's solve this. Because for those who are in our class, really, people who've been waiting 20, 21 months, 19 months, there's something went really wrong, because those people should all have been adjudicated.
Does anybody want to comment on, did we not see some evidence that they are doing something akin to what we're asking them to do between months?
Yes. Yeah. So like what we know that they're doing is that they are reserving a number earlier in the year when they're anticipating retrogression for cases that are still not completely ready, because if they were ready, they would have approved them on the spot rather than reserving a number. And then, because I had somebody who did a consultation with me recently that had been approved, and we were convinced that they were prematurely approved, because the number wasn't available yet. And then we learned that through the ombudsman's office that they have been reserving numbers. Now they are within this fiscal year, but they have retrogressed, so the numbers are no longer available, but they are still reserving that number. So the question for me is, if there's not a number available and the person hasn't been issued a visa, then they obviously are showing more flexibility, at least in those cases. And if they have that kind of flexibility, then why do they draw the line where we're asking them to?
Yeah.
I would note another piece that we discovered actually in the affidavit that we're going to talk about in a second is they do the same thing for DV cases. They allocate a visa to a person before the interview. So when they schedule that interview, a visa has already been allocated. We did not know that. In fact, my experience, I mean, I've literally sat in offices of USCIS officers while they say, I'm gonna call the phone number to get a number right now. So clearly they've changed the process. They're allocating numbers beforehand, but they're not reserving them beyond the fiscal year. That seems to be the kicker right here. So,
yeah,
interesting stuff. Now, Jesse, we have the DV litigation here. Let's just call it Gomez for want of a better word, but I think this applies to current stuff as well. Until I can get Mr. Miles is the head of the KCC.
Yeah.
Apparently, he changed his testimony.
Yeah, I mean, I think the one thing that they've been doing for years is they defend all DV as if it's one case, and it's really not. We all have our separate cases, and we're going to argue for 2020 case and the 2021 cases, which raise similar but distinct issues from this year in particular. But, for years on record, or you can go back and search, they've always said, and it's not an issue with 2020 and 2021 necessarily, more 2022, but they've always come out and told courts that they schedule by regional rank number. And that's the way the regulation is written. So once you're approved, meaning you're documentarily qualified, there was nothing about this allocation of visa. It's just that you're scheduled at post by regional rank number. And that's fairly consistent with the regulation. And that's the way they've said it. And the reason it's become an issue this year is because although they've issued more visas and scheduled more people than they have in the prior couple of years where they refused to do anything for diversity visa folks, is they're going out of order. And there's not, and so they've said one thing for 2020 and 2021, and actually going back to 2017. And they didn't. And then this year, the process revealed that that's not true. And, all of us have litigation, and there's some others who have litigation. And now, because they know they're not following what they said they were following in terms of the process, they've come out and said, little mistake. In fact, we don't. Here's how it works. And it's still not clear to me. But essentially, KCC treats you as ready and allocates a visa to you. They put you in a queue, okay? They give you, then they somehow rank your regional number or regional code, and then they treat you in the regional rank number. But here's the issue, and this is what I think I understand. once you become AV and in that queue, a lower number that comes at later does not take the place of that number if it in fact is higher. But regardless of what the process is, and I'm not so sure anyone knows, including those in the government, you cannot, in my mind, go and make it up as you go along before a court. And that shows that you don't have a rule of reason. You don't have a rule because you came out with one statement and now you're saying there's another statement. And it just shows the arbitrary nature of how you're treating, for me, my clients, and for those in
Same as us.
and you know, their clients. And in fact, it's actually shocking because I don't know, you know, I am the other one, but having worked at DOJ, I cannot believe they allowed their client to do this, which is basically come and say, hey, I actually don't know what I'm doing.
Well, they just changed the rules midstream. That's what they did.
Yeah.
Without telling anybody, without going through the APA, without, which makes it, okay, judge, they can change the rule. You know, you can too at this point. This is unfair. Were they even doing this before? That's the thing. They clearly,
Yeah.
When did they start this change? I mean, you deposed this guy, didn't you?
Yeah, I'm under a protective order
I
there,
know
but
you
I can tell you that what I read on Friday night was news to me. I had never heard that before.
Let me posit a guess. I think that sometimes when you talk to top levels about what's going on under them in any industry, they actually don't know. And so they didn't know, and he learned how things actually work and then changed his tune. So I think that the people who have submitted declarations in the past haven't actually known how it works. And then somebody said, you know what, what we're saying is not accurate.
Yeah.
Wait, are you suggesting that an individual who in the beginning part of the declaration said, I am the person who knows all, I am the almighty Oz, they weren't?
Well, yeah.
I mean, I think that's, and I think that's true of anything. There's things on that I think I know how they work in my office that my staff would say, hey, no, Aaron, you're wrong. This is how we actually do it. And that's just
and the funny thing is, you know,
but you don't sign a sworn declaration saying this is how it is without going to the person who actually does know how it is to say, is this accurate?
and here's my position, and I've actually put this in an email. I said, listen, you want to change the rules, that's fine. I have 29 people who've been affected by that. My job is to make sure that they are actually treated appropriately. And you've now come and said, well, we didn't know what we were doing. And in fact, they've through their own evidence about my clients that they have, that I did not have, that they gave to me, I know they skip people at the post, right? And that's a big issue for my clients because they're depending on me to represent their interests. And so when they see this, they're like, what is this? Like, I've tried to explain it. And I can't come up with an explanation. And so I said, listen, I think we're going to have to wait for the ultimate decision maker, who is the judge, to look at this and decide whether it's appropriate to change your processing rule or your explanation of it through an errata.
Now, I've seen I've had one eye on the comments, and some have been asking what's the next step in our 2022 case. I can tell you that this filing from last week will feature prominently in a filing by us probably in the next week or so, and we'll get together and discuss exactly what that's going to look like. We're not going to talk it through right here, but I think that this was big news that came down. Like you said, on
Friday at 5 o'clock or 6 o'clock or 7 o'clock.
It's funny. Well, and not funny. But in our case, in the Eastern District of Kentucky, our dispositive motions, our motions, which we hope are our final motions, are due August 4th, I believe. And so this and their errata sheet to Morgan Miles's deposition is actually due tomorrow. So I'm just so frustrated because we're preparing for a summary judgment based on what we thought and a large part of that is our allegations that they weren't following the right process for our clients. And lo and behold, they're going to say, well, they are. It's just that you didn't know about it. Like, okay.
Secret. They're
Yeah, like,
secret.
Or no, it's even worse than that. Because if they had just said, we're not telling you, okay, you're not telling me. Fine, you should, but you're not. But it's a totally different thing to say, this is what we're doing. This is how your plaintiffs are being treated. You have no claims. And then come out on the heels of dispositive motions, or when we're waiting for a decision here, and say, actually, what we told you, guess what? That's not the way it was working. This is the way it's working. You still lose.
Oh,
and if I'm a federal judge, which I will never, I mean, honestly, don't ever put me in the bench, but you know, I would sit there and say, just for that reason alone, you've mistreated these plaintiffs, because you've absolutely told them two different things, both of which cannot be true. And
do we get to listen to your oral argument? Because oh my God, this is going to be one for the ages.
I and the funny thing is, and this goes back to a theme of this whole call with all these issues, because it's like we look for issues where we can make a difference, right? Impact litigation.
Yeah.
These are issues where we've tried to have conversations to reveal remedies, like, hey, you can solve this issue that you've created this way. And each time we do it, they're like, no, we're right, you're wrong. And that's why we do what we do.
Well, particularly, it's so funny, and I always go back to this. One of Biden's first executive orders directly referenced the damage done to DV selectees, and directed them to try to remedy that damage. And so why are we having to fight about it?
Aaron, it's only been a year and a half. I mean, you can't expect miracles.
Right.
And the other thing I will say is this. I don't want to say, they came out with a new prioritization policy this year, basically admitting what they had done in years prior was not correct, and not good for, DV applicants. But they came out with a new policy. They have done, better job than they have in the previous couple of years.
Way better. We got to be honest about it. They've done way better.
And it was after the lawsuit.
Better. Let's classify it as expected in previous years.
Sure.
I mean, it's not better. It's just not as bad as it was.
On the other hand, in my case in particular, I started with maybe 100. I think it was 134 plaintiffs. I'm down to probably 30, and most of those are from consulates that, for whatever reason, never got the memo or the cable. And I'm talking about Accra and Addis, and I'm talking about Nairobi, and actually Abu Dhabi to some extent. And I'm sitting here and I'm just banging my head against the wall because I feel so bad for these people, and I want to win for the clients. And if you look at their numbers, it's deliberate. It's deliberate, and there's an issue there. So they've done better, but in fact, at some point you have to step in when you have a post that's not doing its job, and they're not doing that. So it's not like when we say, because people take issues with, you're saying that we have no case. I'm not saying that. We're saying they're doing better, but obviously they have this. They don't understand how actually people get scheduled. That's an issue. They've locked people into certain posts without letting them transfer, and then letting them kind of hang on the vine to see their dreams lost. And
you may have noticed just a few days ago, I think it was 4 days ago, the Department of State planted an article in the foreignpolicy.com about the chronically short-staffed consulates in Africa. Yeah. All the posts, of course, except for one you put the word Africa. Yeah. And yet they lock people in to chronically short-staffed posts. Yeah. Which, I think their post is, woe is us, we have many more people, whatever.
Let me just give you an example though. Like, okay, you've done this, and this is publicly available data. You're understaffed. That's great. Well, if you are issuing 2,000 visas and you're allocating 2,000 for diversity, 2% for diversity visa applicants who have a strict timeline, that's not good with me. That doesn't fly with me. That's not a staffing issue. That's a choice.
Yeah.
And so that's where I come across. It's a good example of why reserving visas would be
so useful in terms of just even in normal years when there's problems that are happening in certain consulates where they could have that flexibility to take them past the end of the fiscal year on there. If they have and why fight that? Why not let a judge basically tell them that they can do that, or ask a judge to let them do that? I mean, it's if they're not going to get it, if a whole region of the world is not going to be able to get it done in a timely manner, then that's the perfect reason why you'd want to reserve, even in a normal year, non-COVID years.
And I got to be honest with you. I think if they were to redo the diversity visa program, they should do it like they do every other immigrant visa category. And they should not let these people suffer with this timeline, because it creates ridiculous anxieties for the department and for the applicants. They should just say, they could just do it in a category. I'm a 21 DV. I've been waiting for X, and when you get your interview and appointment, you get it. But they should not let people just, allocate the 55 or 54, 850, whatever it is, but don't make them have this ticking time bomb where they see their dreams lost because they can't get a 10-minute interview.
Right, or at least make it so that if the applicant has done everything that they're supposed to do, that they're not going to be punished.
Sure.
It's a different story if somebody waits till September 15th and files their application then.
Yeah.
But if a person has acted in a timely manner, then the government should stand behind behind the process.
And this raises an issue, and I'm not involved in litigation on this yet, but this raises an issue because one of the things that I've seen increase dramatically is across all immigrant and actually non-immigrant categories is people being placed in AP and being asked for a DS 5535. Yep. And then you're in this black hole. And I think there's going to be a lot of, I know others out there say, well, they'll do a lot of decision making in August and September for those in AP. But yet, if you're one of those people who are like, okay, that's great, thanks for letting me know that. But if September 30th passes and you're a DV applicant in administrative processing or have been refused, you're out of luck. And I don't know if you guys are aware of this, but that Montreal has placed, I don't know how many people in AP.
Why is Montreal doing that?
I don't know.
They've always done it. Montreal has always done that.
But for DV in particular, or for just
for everything? They do it for everything.
Yeah,
they're in the Milligan. I think in the Milligan case, they were one of the worst consulates in the world.
They were terrible, absolutely awful.
Yeah,
I mean, if you're Canadian and you want to marry an American, do not do a K1. By the way, don't ever do a K1.
But I mean, I guess so to tie it in a bow here with DV 2022 at least. Well, maybe 2020. I mean, September is going to be a big month because we're going to have oral argument in Gomez Good Luck Go, and the other 35 cases that are now together with that. And then for DV 2022, either the department is going to take affirmative steps to resolve these cases, or we're going to have judges issue decisions.
Well, there we go. Let's answer some questions. All right. I'll go back over here and take this as a note out here. All right, let's answer some questions here. Elmedi, everyone, what does the last gov? Oh, yeah, we already talked about this. Thank you, Elmedi. Do you see his picture? He's got a little Don Corleone action going on there. Frostman, Jen here again. Well, was going to ask if we're going to go. All right. By the way, the court in Go just sent a letter out to the Jillian lawyers in this case saying, hey, tell us what you're going to argue, who's going to argue, what you're not going to argue, and do that by August 12th. So yeah. We'll be meeting with I consider the Gomez folks kind of the lead on this because they've been around the longest and they got this team. So
you may, just so you know, I think I've been tasked with the argument, so you can.
Jess, it's going to be a blast.
So you may want to you may want to shift your time and allocation.
But Gent here is asking about the systems update, which was interesting. The government was required to file a report saying, "Hey, how's your IT update going?" And so they did, and what they said is their systems are ready to go. Should they be ordered to produce the reserved visas, they will need to run, I think they call it a script that'll take a few minutes at each post, and then they will be ready to do it. So they're ready to rock and roll, supposedly, if we prevail.
Can I just put in at this point now that they spent like $500,000 to do this? You already mentioned that Biden wanted to take care of diversity visas applicants who are mistreated, and yet we have to go and litigate this. I mean, so if don't put me behind the bench, because if my first issue would be, excuse me, government, you spent $500,000 in taxpayer money to remedy what you knowingly harmed, and yet you're asking me to issue a judge. I'm sitting here in September on this black robe and it's hot, and you're asking me in DC to make this decision. I'm confused. I'm mad. I'm just so mad about it.
Well, I'm still confused why they're appealing. I mean, why are they fighting on this issue? What is the policy? I mean, obviously, but I mean, they have to have some kind of policy justification as well when a judge to try and go over it. Or, it can't be just surely because they think the law is great.
I think the biggest things for them has always been the 1182F. Like if we suspend entry, if a president suspends entry, that means we get to do no work. That's a big thing for them. But the biggest thing for them is having a judge tell them that they can do what a statute tells them they cannot and reserve visas. And that's a huge, danger zone for the government because, again, like you said, power, separation of powers. If Article 3 can tell, Article 3 is a judiciary, if they can start telling, Article 1 and Article 2 that we have equal authority, which pretty much fundamental for me, the government does, the other branches, right? The executive branch doesn't like that. And that's the battle. And in fact, they're going to a court who's already said somewhat, I mean, it was pretty much a holding that, yeah, we can reserve visas. Yeah. If you mistreat people, sure.
Well, I mean, that's the whole thing that Judge Mehta addressed, I think, in each of his decisions, in Gomez and Go and in the others, was if I don't have this power and equity as a court, then there is no remedy, and that can't be right. The government can just sit on these cases until the very end, and then I rule against them, and it doesn't matter.
Yeah.
And so the court's flexing its power as it should.
Maybe it has something to do with like some of these other issues, like prosecutorial discretion, other things where they don't like and we're with the government on those issues as far as the judge saying, basically striking down an entire prosecutorial discretion system that has been created. And maybe they think that. But on the other hand, they've argued there have been cases as well where they didn't take up Trump executive authority positions and let them, play out on their own as well. I think that wasn't in the public charge. I'm trying to remember the issue that a couple months back where, they backed off making these same kinds of arguments. It seems it's very specific to the issue that they have in mind, whether they do it or not. But I feel like in this issue, they don't want to. It's not a question of whether they think it's sort of in the big picture separation of powers. I think they just genuinely don't want the extra work and have a judge tell them that they have to do the extra work. I think that has something to do with it. They don't think they're ever going to catch up.
You mean the work that they just spent the money updating the IT system so they can do it, right?
Well,
so
didn't they pay somebody outside to do all that work for them?
Yeah.
So from their perspective,
500,000.
I don't think they consider it that their work. They consider that the check that they wrote for somebody else to do that work as opposed to their internal people.
And at the end of the day, too, like, what they never understood and what I never understood when I was working for the government is the human part of the story, because we have 9,000 maybe in 2020, and we probably, I don't know how many total we have in 2021, but it's a game changer for these people's families. Like when I talk to the clients and one by one, and we're talking about 20,000 people, and we've already saved thousands, but I mean, that human aspect of the story, if you sat down, I guess with maybe the president or someone and explained exactly the human, kind of torture that they're doing, these issues become ridiculous to litigate. And that's hopefully what I'll try to drive to the court, drive through the court. Like, hey, like, this is pretty horrific what we're doing. But
amen and amen. What are we doing for the 12 plaintiffs in the DB 2022 case?
That's what I referenced before, where we're going to have a filing with that declaration from the errata featuring prominently, like I said. Our role is to try to get 12 remaining people interviewed. It should not be that hard for them to do that. And it should actually be much easier than continuing to litigate through the end of the fiscal year. So
you know what's incredible, and I know I'm you guys, people are probably rolling their eyes, but you know what's incredible, when I've tried to settle this case and I knew something was off with the process, and they told me, well, if we settle yours, it means that we're skipping people. And I'm like, now it's like,
It's hilarious.
I feel like I've been duped, it's like, what? I know but
it's hilarious. Like we're skipping people, like we haven't skipped 100,000, 50,000 people already. It's just
you could teach, if I were ever going to teach.
That's all they do is skip people.
If I was going to teach like an APA class, I think you could really use the last 5 years, starting with Al-Makrami in 2017, and teach like an APA litigation class, just on DV litigation. Like and people think that the lawyers have been the catalyst, and that's not true. That's not exactly it. I mean, there's been so much thrown at this program. Doesn't make sense.
Yeah, but where would this program be without these lawsuits?
Oh, there would be no program.
No, there would be. They would continue to get 3,000 people a year get DVs. We all know that. We all know that's the case.
Yeah.
All right. We got Cy. Cy, after basically 2 years, gets his EBAUS moved out of Nebraska to the National Beneficent. Does this mean you'll be adjudicated by September 30th without court intervention? No. I don't think so.
No, and we know what's happening. I think you probably are more aware of it in your own cases, but what's happening is that they're trying to involve the field offices as much as possible. But, it's like, okay, let's add a layer of arbitrariness on this, because depending on what field office you go to, they may be too busy to get to you. I
know through the grapevine that the field offices are getting a lot of pressure to treat these as a top priority. And so that's good news. Hopefully they'll be flying out of those. But
I think too, but even if we bring in maybe a removal based, because Aaron, I know I have a removal background, and I know you do too. It's almost like when ICE headquarters comes out with a policy, even PD, even prosecutor discretion, and you go to the field office and say, implement this. You get disparate, distribution, and that's my fear, but also my hope, because I do think it's beyond that these people are priority. I mean, you could not make any more promises to a certain category of applicants than what's been made. It's
crazy stuff. When do we think the DV 2022 lawsuit we will get from the judge? Well, Aaron may get his. But Jesse may get his by the end of August.
Yes.
Ours will be by the end of September, like always. And hopefully by then, every one of our plaintiffs will be adjudicated, and we'll just dismiss the case. I could tell you, that's what Judge Mehta is hoping. I can tell you that. Timeline on the PI. Correct me if I'm wrong, Aaron, but once we file the PI, the government has 10 days to respond. Is that right?
I want to say they have 2 weeks.
It might be 14.
I need to look at that. But the timeline after we file it, you go back and forth on briefing. Then the judge decides whether they're going to set a hearing or not. So you're probably looking at about a month until there's a hearing.
Yeah, so probably September, which is fine, because again, this is about getting cases adjudicated and reserving. We just need an order by September 30th if reservations are, ultimately are needed, if they don't use all the numbers. So the judge will issue a quick decision in this case. Based upon our experience so far, I don't have any doubt about that. No surprise here. Judge Derry confirms to me that immigration is not part of the revised reconciliation talks. Yeah, Jack, no, we're not even going to talk about that, because do I need to remind you that was never going to pass? Did I say that before? I believe so. Is going to the Supreme Court?
Jesse says yes.
Jesse thinks they're going to go all the way.
I think they will. Well, again, you also, number one, the government's going to take a look at the decision and see how bad. It's not as if they're in a court that doesn't know what it's doing. We've seen a number of the Supreme Court justices come from that court, and but I think they are in it for the long haul for sure.
Yeah. Is Chuck arguing that unless Aaron usurps my position and wants to argue, Sounds like it's the Jesse and Chuck show, and I assume
Curtis.
Rafa will be there, and I don't know who else will be chiming in as well.
Yeah.
But
Yeah.
this is going to be fun. We do not know the panel and we won't know the panel until probably I think early September, late August.
Yeah.
Europe does not want to give Schengen visas for Russians in close time. We'll need to flight to Brazil for Russians.
I've had a number of Russians do well by transferring to Brazil.
Yep. So might want to do that.
Like yesterday.
Yeah. By the way, you can also go to Panama City visa free as a Russian. So Panama might also be an option. Let's see. Not sure what algorithms are used to transfer. Oh, the transferring cases in the I-140 EBAOS, I don't think anybody knows how they're doing it. There's no system. There's no system. Hey, Bob, I found a box in the back room. Oh, send that down to NBC. That might as well be their process. I don't know.
It's really an example of where they've made the problems larger than they need it to be because they're creating a paperwork jam. Like
the Peter principle, need I remind you, I received from a congressman a response to inquiry that 2 months back. They will receive it on my 45J. Okay, what about your 485?
Yeah.
Who cares about the 45J?
Yeah.
There's no decision to make on a 40. It's not, look, dude, you didn't submit and say, I got my I-140 approved as a computer systems engineer, and now I'm working as a janitor. Nobody did that, okay? They're all going to be approved. All right. Let's see. By the way, you should hold the government accountable in front of the judge for lying. I can't wait to hear Jesse's oral arguments.
I mean, I don't have a lot to, but the thing about it is, sometimes best to stay quiet. I mean, I'll be loud here and in front of the audience, but I think, I don't know how you can explain it. I've really racked my brain about it.
Sometimes just my experience is let the judge, these are smart women and smart men. They read this stuff. They are prepared.
Well, here's what's, and you've had filings. So there are pending, like in our case, it was a pending motion to dismiss. In your case, I think it was pending motion for preliminary injunction.
Right.
So judges and their clerks have invested time to decide. And now you file an errata, and that would annoy me.
I agree. Look, there's no way to find out who the government lawyer is in our case. They will respond to the PI, whatever.
Yeah,
they're also not USCIS lawyers. They're either DOJ lawyers or oil lawyers. So, and honestly, I don't really care who the government lawyer is at this point. They just need to fix the process.
Yeah.
Are they going to process? Okay, again, the DV 2022. There will be no news on that until December or January. It's really that simple.
Yeah.
Speaking for the team. All right. Let's see. EB wastage. Let's see. Since Benias law is getting re-updated, so it'll be helpful for the Madabin wastage case. I don't know. I'm not following Benias law, so.
Yeah, I think you can find updates for our lawsuit right on the website.
On the website, yeah. And plus, we're literally here every week answering questions. So you don't get more update than that. Let's see. Jack Sparrow, got to look at this couple last. Say we file PNN this week. Can we do something to expedite response? The PI is the expedited response. That's how it works. That's the.
Well, I think too. What people need to understand is, it is July 26th, and we are in a short timeline. But giving a little bit of air to the lawsuit will allow them to actually, as we all seen in every case, pick off plaintiffs, right? And we want to win for every single one of our plaintiffs and then the class. So we can kind of do a deliberate pace, but there's no if you wanted a decision tomorrow, you'd file a temporary restraining order. We don't need to do that. We have a timeline that is going to put us in the most optimum position so that the class wins and individuals win as well. All right. And it's funny, right? So here's the thing that people need to understand. We have an opposition who actually agrees with our central tenet, which is these visas should be issued. That's very rare.
Yeah, very rare. So we will, we don't talk about other firms' work. We don't, and the reason we did this the way we did is we want to change the system. It's, IMMPact's about changing the system, getting this thing to work for everybody. And I'm just so proud of our plaintiffs for joining us in that fight. Sounds like we got another fight coming up for our friends with United for Ukraine. I'm excited about that. That's going to be a lot of fun. You're welcome, immigration, for helping you fix your problems. And I don't have anything else, guys. This is we're in the dog days of summer, so let's just keep up the good work.
Yeah, I think the heat's getting to me in New England. It's
Yeah.
been really hot. I'm usually more calm, but I think it's been like 100 degrees for a couple too many days. I need to.
We've had it. I'm in Chicago now where it's nice, but in Memphis it's been like over 100 probably for 30 days of summer.
See, that's the beauty of Atlanta. It never goes over 100 here, ever. It never goes over 100, except for the humidity.
Yeah, I need to go to Colorado. I think that's.
Oh, dude, I was in Utah this weekend. The mountains aren't helping, is all I can tell you.
No.
Just avoid the fires.
It's a dry heat. We'll see you guys next week.